On this one,
They're asking for some modification.
modification. Let's see, sit for hearing. Let's see. Okay. Come on, okay, on this Raymond Spike case 22-39094. Were both parents sentenced in this case?
Yes,
Same sentence?
I believe it's the same sentence. They're both on probation.
That's what, right? Or just PMC.
Yeah, I have no idea. It's all these I have the criminal side.
Then down the hall. Terminated? Were you right? Terminated?
Where is the child now?
With the mother, with the grandparents.
Grandparents. The defendant's rights were terminated.
One of the mothers.
Both of them, I believe,
Both
were
of them?
terminated. Yes. And
Which grandmother, maternal or paternal?
Paternal, you're beyond. Paternal.
And you are not to have any contact with the child, right?
Correct.
Okay, what are you asking for?
Judge, we're just asking for some sort of contact. It may be a jump to go to full rights, but I think that the court could use something like supervised contact in the presence of the guardian.
You said it was pre-sentence.
Might
it was a
help.
post PSI.
Somewhat similar to the family court's use of what they call a break-in period.
This same thing that's in the probable cause.
Yeah, it's just not as much information. So I think it was done post.
Here. Thank you.
Judge, it feels a little early in all of this for me to go to visitation. I did speak with the probation officer this morning. He said that the defendant has done parenting, anger management, things like that, which do make me feel a little bit better. There is a class that I don't know that we typically do it on injury to a child cases, but the chaperone class, when we have people that end up on probation for child sexual abuse cases, that whoever is going to be the supervising person or persons, it's done through the probation department. So in this case, I guess it would be his parents could attend that chaperone class to help them. At a minimum, I would want that done before we consider any supervised probation. I don't know that we've typically done it on an injury to a child type situation. It's more on sex offenses, but I think for what it is, for what, it's just to ensure that the child is safe, that I don't think that is too much to ask of the people who have custody of this child, to make sure. I mean, everybody was around when this instance happened in the first place. So, I mean, I would ask that be done if we're going to consider that first.
You're just looking for a plan or a process to where this can be.
I will allow that then temporarily and review it in 6 months.
How long is that for? Okay.
We review it in 3 months at the end of that class, Your Honor.
It's a 3-month plan.
I believe so.
Where are your parents?
Here.
How does this work? Custody of the children, essentially?
Yes, we have permanent managing conservatorship.
Mm-hmm. And what is your sense of all of this whole case?
Personally, I don't know what happened. No one was ever able to tell me what happened. Not the attorneys, not CPS, nobody.
Not the defendant?
The only thing he said was he had her in her arms, was taking her to bed. He tripped, and him and her both came in contact with the wall, and she didn't cry. He put her to bed.
That's it?
That's it.
No, it's
And
not.
then 2
No,
days
it's not.
later,
So yeah, 48
They-
hours, the child was suffering with a serious injury.
yes,
Okay.
she was having seizures that couldn't be seen.
All right, I sense you're a little defensive for him. I find out.
That's all
I'm
I've
sorry,
been told.
I was speaking when you just rudely interrupted.
I'm sorry.
This court is going to take a firm stance in these kinds of cases. And the people involved in this probation methodology, anybody interferes with the strict adherence to these rules will be dealt with severely, isn't even the term. Most severely. When there's young children who are helpless and not independent, this court, the children then become really under my care, my rules, my directions. And if somebody under this court's directions puts the children in harm's way or fails to follow any of these directives, 100%, everybody involved with that will be dealt with severely. Just wanted everybody to know. Because it wouldn't be the first time we caught somebody bending the rules. Because it happens. I know it happens, especially when you got familial situations here. But he has no contact with the child. Now, you can shake your head. I find out otherwise, and people are going to go to jail for a long time. And take care of the child that way. You can't do that in the family. I wouldn't let the family touch the child. After that, does everybody understand? We're going to wean our way into a proper method of dealing with him because we don't know what happened. Yeah, we do. He knows what happens. He pleaded guilty to this, right? You pleaded guilty to injury to a child under oath. And if anybody attempts to say, well, I just did this to get probation, then I'll put you in jail again because you would have lied to everybody. You swore out that you committed each and every element of that crime, which is one method of attempting to purge yourself from the wrongdoing. But I find any step along the way not being done honestly and forthrightly, according to the law and the court's directions, it will be dealt with severely. And it happens in here a lot that the rules aren't followed. And when you got my attention, it will be handled by this court in a stern way. That's just the way it shall be. Does everybody understand that? It's a little child. I've got children and grandchildren, so I know how special they are. And sometimes accidents may happen. How you handle the problem is what got you in here. You have to handle it responsibly. Because they're 100% dependent at this age. How old was the child? Just months old.
4 months old.
4 months old. I can't. That's horrifying to this court. A child of 4 months is put in harm's way by the parent, or the way you handled the error, whatever it was, accident or not. The way you handled it is, well, we take care of children and invalids and people who just aren't independent. This court is going to make sure that they're taken care of, but y'all are the family. Nobody should be first in line other than y'all on taking care of children. My goodness. Were your parents good parents? Yes. Okay. Well, then the most important gift you can give as a parent is a good example. Okay. You got to work toward doing that, you know. But anyway, we'll see. We'll modify the terms, do that 3-month program, and then come back and see where things are.
Thank you,
Okay.
Judge.
You, ma'am, look exactly like my cousin. I have a cousin who looks just like you. I mean, for a second there, I thought you were Jennifer. Brown, who's a great dance teacher. Teaches. She is. She's an award-winning dance teacher.
I used to
From
work
Port
there.
Neches. Yeah. Okay.
Judge, I have one more request. It's
Yeah.
I believe it's much easier than the last one.
Go ahead.
Mr. Spites has advanced himself towards a career of truck driving. He is taking the truck driving school. That he has an employer that wants to send him on some short runs that are going to be outside the area, which will be travel. And so what we're asking for is a travel permit for work purposes only.
Any objection to that? I don't see that as a problem. Just keep up with the probation office. The plan, okay? Because we don't want anybody to say, well, we saw the defendant in Mississippi. Did y'all know that? No, that probably would never happen. You know, but if that happened, I would go, well, let me check with the probation office. And somebody says, no, we didn't know that. Then you're in trouble. Just keep us informed. But we want you to get a job that's a good paying job, that's responsible work, right? Yes. Okay. Yeah. Yeah. It's just fix this. There are ways of fixing it so that everybody in the household can get together and live happily. Thanksgiving and Christmas time. I hate seeing people not together in a family because that's special. Okay, anything else?
No.
That's what we'll do. Thank you very much. Yes.
Crazy! Oh, now it worked on the one time. Okay, so we are going on the record in the matter of the state of Michigan versus Tamonte Carter, 232336. And counsel, your appearance, please.
Your Honor, good afternoon. May it please the court, Richard T. Serrano, P33828. I appeared this afternoon on behalf and with my client via Zoom, which we have no objection to, for a purpose of arraignment on a number of charges listed in the complaint.
All right, sir, your name for the record, please.
Hey, how you doing, Your Honor? My name is Tamonte Carter.
All right, fine, thank you. And Joe, did he fill out the court-appointed form?
Not yet. 3, but then proceeds to be count 4 and 5, which appear to be both felony firearm. And we wanted to know if those were in fact 2 counts of felony firearm and why the defective numbering and count 5 and 6.
Okay, so there are a total of 5 counts. The defective number appears to be from the typist at the Wayne County Prosecutor's Office. Count 1 is stolen property, receiving, concealing motor vehicle. Count 2 is fleeing and eluding police officer, 3rd degree. And count 3, and the numbering system is skipped. It appears to be a clerical error. So then count 4 and 5 are felony firearms, and that's 2. That's because there's a receiving, concealing, and then the fleeing and eluding. So then there's 2 felony firearms. And then there's a count 5, a 5th count, I should say, which is count 6, resisting and obstructing a police officer. That's at the one line at the very bottom of the first page and the top of the second page. So there are a total of 5 counts, even though it says there's a count 6, there's all 5 counts. Count 3 was missed.
I understand, Your Honor. So 2 counts of felony firearm was my client's, one of his main questions. Do you understand that now, Mr. Carter, in addition to what we talked about?
No, I do not, sir.
What, well.
Okay, counsel, let me just do this. I'll just read the charges. How's that?
All right, we were prepared to waive formal reading, but it would be better if he understands fully, Your Honor, of course.
Okay, the court will state that on November 1st of this year, in the area of Biddle Avenue in Wyandotte, Michigan, there's a count 1, stolen property, receiving, concealing motor vehicle, where it's alleged the defendant did buy, receive, possess, conceal, or aid in the concealment of black Chrysler 300 a stolen motor vehicle, knowing or having reason to know or reason to believe that the motor vehicle was stolen, embezzled, or converted. Contrary to MCL 750.535(7). This is a felony charge. Maximum penalty upon conviction is not more than 5 years in state prison and or a $10,000 fine or 3 times the value of the motor vehicle, whichever is greater. Count 2, fleeing a police officer, 3rd degree. It's alleged on the same time or same date and location, the defendant being the driver of a motor vehicle to whom was given a visual or audible signal by hand, voice, emergency light, or siren by Adam Grote, a police officer who was in full uniform, and the officer's vehicle was identified as an official police vehicle acting in the lawful performance of his duty, directing the defendant to bring his motor vehicle to a stop, did willfully fail to obey that direction by attempting to flee or elude the officer, and the violation resulted in a collision or an accident and in an area where the speed limit was 35 miles per hour or less. Contrary to MCL 257.6028(3). This is also a felony charge. The maximum penalty upon conviction is not more than 5 years in state prison and or a $1,000 fine. Secretary of State shall suspend your license for 1 year. This is the 3rd count, but it's numbered count 4. Weapons, felony firearm. You did have or carry in your possession a firearm where it's alleged that on the same date and location this occurred, a handgun at the time he committed or attempted to commit a felony, that felony being receiving concealing motor vehicle. This is a felony charge. It's a 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Mandatory forfeiture of weapon or device. Count 5, which is the 4th count, but it says count 5. Weapons, felony firearm alleged on the same date and location. You did carry or have in your possession a firearm, that being a handgun, at the time you committed or attempted to commit a felony. That felony being fleeing and eluding 3rd offense. This is also a felony charge. The maximum penalty is 2 years conviction with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Mandatory forfeiture of the weapon or device. And it says count 6, but it's the 5th count. Police officer assaulting, resisting, obstructing. It's alleged on the same date and location that you did assault, batter, wound, resist, obstruct, oppose, or endanger Adam Grote, a police officer for the city of Wyandotte in the Wyandotte Police Department, that the defendant knew or had reason to know is performing his duties contrary to MCL 750.81(d)(1). This is also a felony charge, sir. The maximum penalty upon conviction is 2 years in state prison and or a $2,000 fine. Do you understand all of your charges?
Yes, Your Honor.
All right, counsel, just so you know, there are multiple typographical errors or missed letters and spelling, so I'm confident that it was just a clerical typographical error with the numbering system. And so the court will also enter a plea of not guilty on your behalf. Sir, you have the right to have an attorney. If you cannot afford one, the court will appoint one to represent you. And you had an opportunity to speak to an attorney today, correct?
Yes, Your Honor.
And you understand you have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yes, Your Honor.
I've already entered a plea of not guilty on your behalf. I'm scheduling this matter for a probable cause conference on November 9th at 8:40 a.m. And counsel as to bond.
Your Honor, after speaking to my client, he did say he wants to apply for court-appointed counsel, but he may, in fact, hire his own attorney if he can raise the funds. Your Honor, my client is presently lives with a significant other and one minor daughter, aged 2 years old. He lives with his sister, but he does support a daughter that is with the daughter's mother. And Your Honor, the court will notice that my client is not working. He recently lost his job, and his financial condition is not good. He is presently on HIDA status probation. His court, examining his criminal history, he is presently on HIDA, has not been able to speak to his probation officer in that matter yet. I've advised him to do so and to contact the attorney that represented him on that matter. So my client understands the possibility that these cases would have on his HIDA status. Your Honor, he's told me that he's never failed to appear in court before. He has a valid Detroit address with his sister. We'd ask the court to consider a bond he can reasonably expect to post, Your Honor. And at this time, we leave it in the court's discretion. Thank you.
And what are you currently on, height status for, sir?
So it was for a 3rd-degree arson. I was with somebody committing a crime. I was the only person that got caught.
How long have you been on height status and probation, sir?
For about a year now. It was almost done. I had 2 years of probation.
It also appears as though you were on height status for felony receiving concealing stolen property, correct?
Correct, yes.
So 2, you're on height status for 2. And also 4th degree arson, correct?
Yes, correct. I thought it was 3rd degree. I'm sorry.
No, 3rd and 4th. You have 3rd degree and a 4th degree.
Correct, Your Honor.
And why aren't you working, sir?
I didn't hear
Sir, why
you.
aren't you working? Why aren't you working?
I lost my job like a month and a half ago. I was late to my orientation. I used to ride the bike to work, and I was an hour late, and the job was so strict, they wouldn't allow it. So I recently, it's an app called Variable, where you could just book a shift, go to the shift, and clock out, and they pay you daily. So I was doing that day to day.
Okay. And how long did you work there, sir?
I say for about like a week max before I got all the way in. Before that,
And so when was the last time you had a job before that?
the last time I worked the job was like a week ago, week and a half ago. But it's on Variable. Variable is an app that you download on your phone, and they got jobs all across the city on it. Variable.
Okay, I didn't understand anything you just said, sir.
You said
A
what
week
you
and a
said?
half ago? I didn't understand anything you said after you said a week and a half ago is when you last worked.
The last time I worked the job was like a week and a half ago, Your Honor.
And where was that? I didn't understand what you said.
It was through the Variable app.
Through the what?
Through the Variable app in Detroit. Variable. Veryable.
Oh, very able. Okay, is that our temp service, sir?
It's like a job app on your phone. Yes, it is like a temp service app. Yeah.
Okay.
They pay
Okay.
you same day when you clock out.
Okay. All right, and Detective Sabo, your name for the record, please.
Detective Steve Sable, Your Honor. And
All right, thank you.
thank you. And since Mr. Serrano mentioned about the HIDA and it's kind of expanded or expounded on with the court, the weapons offenses and receiving and concealing, I don't think that it's unreasonable due to the incident and the severity of it that Mr. Carter is a danger to society. And he's had many opportunities on his probation, et cetera, to stay straight. This is a pretty serious offense. So we're asking $100,000, 10%, GPS tether, no drugs or alcohol not prescribed, and certainly no weapons. Thank you, Your Honor.
All right, thank you. The court will note after hearing from Mr. Serrano, hearing from Mr. Carter, hearing from Detective Sabo, reviewing the criminal history, and noting that there are multiple charges of Mr. Carter that are similar in nature to the current charge he's facing, and the fact that Mr. Carter is currently on probation for 3 charges, one of which is the exact same charge that he is being charged with here today. The court, and given the nature of the allegations, the court does find that Mr. Carter is a danger to society, as well as the fact that he has a hard time complying with court orders. And I don't believe that he would necessarily comply with the court orders. Hopefully, a monetary incentive, $100,000, 10%, would be helpful to Mr. Carter. In the event bond is posted, GPS tether through the Wayne County Jail. house arrest. That way we can be sure you're not driving because you don't have a valid license anyway, it appears. No driving in the event you think that you're going to. No alcohol or drugs unless prescribed, and no weapons. Do you have any weapons in your home, sir?
Oh, Your Honor.
I'm sorry?
Oh, Your Honor.
Did you say no?
Oh,
Okay. All right, anything else?
I have nothing further, Your Honor.
All
No,
right,
Judge, thank you.
November 9th, and the court will sign the order for court appointed attorney. All right, so don't go anywhere, Joe, with that remote because Detective Carr is right behind you for the PPO violation here. All right, thank you. I don't,
Thank you, Your Honor.
Oh, thank you, Judge, appreciate it.
All right, thank you. Okay, I guess, well, we won't have a case number because, all right, thank you, Mr. Serrano. Yeah, the next individual has retained counsel.
All right, Your Honor, I'm standing by if there's some other late arrival. If not, have a nice weekend.
Okay, you as well. I'm hoping there's nothing else after this one, so.
Thank you.
All right, thank you.